Well, I'm back. I wasn't expecting to be, but there's a lot of activity tonight going on the docket. Okay, so there's two filings I want to go through, two new ones. Very quickly, Lively has tried to, she's filed a motion to, again, seal portions of her motion, which is not yet on the docket, to exclude the opinions and testimony of yet another a Wayfarer expert, this time James Hegarty. I haven't done much with him, so I won't comment too much on that. This is literally a page. The full motion seeking to exclude Nicole Alexander is now on the docket, but I will do it as a separate video tomorrow because it is a whopping 30 plus pages. I think it's 35 pages long. And that's not including any of the attachments. So that's going to need its own video. But yeah, so on behalf of Plaintiff Blake Lively, we write to, pursuant to Rule 4B of Attachment A of the Court's individual rules, to respectfully request that the Court preliminarily seal portions of Miss Lively's motion to exclude the opinions and testimony of James F. Haggerty, as well as Exhibit 2, filed contemporaneously herewith, which was designated as highly confidential. In accordance with Rule 4B of Attachment A and the Court's order, Ms. Lively respectfully requests that the Court not rule on this letter motion to seal for 1 week so that Ms. Lively and the defendants, together the parties, have the opportunity to meet and confer, and the parties and or any third parties may file a motion for continued sealing if they so choose. So it's not much, but yeah, just to let you know, she has actually filed that. These are all the attachments that go with Nicole Alexander's the motion and memorandum to exclude the testimony of Nicole Alexander. So I would do that separately. But I am here because I want to go through this. No, that's not the right one. That's the notice. I want to go through this. Right, so it's not long, 9 pages. Okay. So this time it is Wayfarer, Endless Movie, and Tag. So this is not just Tag. All right. So they have renewed their motion for judgment on the pleadings with respect to the FEHA claims. So, okay, let's read it because I skimmed. It's great, but I want to read it properly now, which I'll be doing first time now. Wayfarer Studios, It Endless Movie, and Tag respectfully submit this renewed motion for judgment on the pleadings on Lively's retaliation claims under the Fair Employment and Housing Act. In its April 2nd decision, the court ruled that any sexual harassment occurred, if at all, in New Jersey, and as such was not actionable under FEHA based on California's presumption against extraterritoriality. It thus dismissed Lively's harassment claims under FEHA in their entirety. And that's kind of important to know because it's not just her employment status and the fact that she was deemed an independent contractor. It's actually where the alleged, harassment took place as well. There's a number of reasons. There's not just one thing. That ruling is also dispositive with respect to Lively's companion FEHA retaliation claims. In short, FEHA prohibits retaliation against someone who has opposed any practices forbidden under this part. And they've italicized the words under this part. The court has ruled that the allegedly harassing actions of the Wayfarer parties were not subject to or forbidden under FEHA. Accordingly, Lively's alleged opposition to these actions was not in opposition to practices forbidden under that statute. her FEHA retaliation claims must be dismissed. The court noted this issue in its April 2nd decision, but did not address it because it was not raised in the briefs. Defendants respectfully submit that this issue, which is purely legal and ripe for adjudication, should be ruled on prior to trial. Resolution of this issue will significantly reduce the scope of trial. Without the remaining FEHA claims, Wayfarer and TAG will be dismissed from the case. Dismissal of the FEHA claims will also simplify the issues for the jury, including by eliminating the question of good faith opposition and permitting it to hear a single set of instructions on contract liability and damages. Finally, pre-trial resolution will also avoid the unfair prejudice of putting defendants on trial against non-viable claims of unlawful retaliation. So, to make kind of set the scene, if they're successful with this, and we'll go into the argument in a minute, but if Wayfarer actually are successful in arguing this and Judge Lyman grants this, that knocks out the two FEHA retaliation and the aid and abetting claim. But it only leaves the contract rider agreement, contractual claim then. That's all that would be left. And that would be against, I think it's just, it ends with us. Yeah, it ends with us maybe. Possibly Wayfarer, but I'm pretty sure it was just, it ends with us maybe. Without looking at it, I can't quite remember. But, yeah. I think it would be purely, it ends with us maybe. Okay, Lively has no FEHA retaliation claim because she did not oppose conduct forbidden under FEHA. Under FEHA is an unlawful practice for any employer to discharge, expel, or otherwise discriminate against any person because the person has opposed any practices forbidden under this part, or because the person has filed a complaint, testified, or assisted in any proceedings under this part. As the plain language makes clear, FEHA protects employees against retaliation for opposing conduct made unlawful by the Act. Under California's presumption against extraterritoriality, only unlawful discrimination having a substantial connection to California is subject to the statute. The court has held that Lively's harassment claim lacked such a nexus to California because Lively was not a California resident and all the relevant conduct occurred on set in New Jersey. The necessary corollary of this holding is that Lively was not opposing practices forbidden under FEHA when she complained about alleged harassment that was in no way, shape, or form subject to FEHA. A contrary result would read into California statute a remedy for employees in other states who experienced and opposed discrimination in those other states, so long as a subsequent adverse action is directed from California. But that is not what FEHA provides. California has not forbidden employers in New Jersey from harassing their employees, and employees in New Jersey who complain about such harassment are not complaining about harassment forbidden under FEHA. That makes sense. In its April 2nd decision, this court cited eShares Inc. for the proposition that when retaliatory conduct is directed from California, a FEHA retaliation claim does not offend California's presumption against extraterritoriality. The issue raised on this motion is different and was not raised or decided in eShares. Instead, the relevant pleading in eShares makes clear that the retaliation in that case arose from discriminatory acts that occurred in California. Nor is it sufficient for Lively to claim a good faith if mistaken belief that defendants' actions violated FEHA. Such a belief must be objectively reasonable when measured against existing substantive law. Thus, a plaintiff may not use a legally erroneous belief to expand the statute beyond the categories of discrimination addressed by the legislator. A plaintiff who erroneously believes the law forbids categories of discrimination that it does not in fact forbid has no retaliation claim if she opposes that discrimination and gets fired. The same goes for a plaintiff who erroneously believes herself protected by the law of a faraway jurisdiction. Lively was a New York resident shooting a movie in New Jersey, and all the allegedly harassing conduct took place in New Jersey. She was never protected by FEHA, and she did not oppose conduct forbidden by FEHA. She has no retaliation claim under FEHA. I really love this argument. This is a really good argument. I mean, it didn't make sense, right? I'm kind of just interjecting here, sorry. It didn't make sense that the claim was dismissed. The FEHA sexual harassment claim was dismissed. But you're keeping in the FEHA retaliation claim because Lyman did make it clear that there was no nexus to California. So it did not make sense why FEHA stood. So this is a really good argument. Okay. This issue should be decided before trial. Under Rule 12C, a party may move for judgment on the pleadings at any time after the pleadings are closed, but early enough not to delay trial. And Lively will come back and say, it's too late, we're too close to trial. She'll do all of that. The argument that the plaintiff has failed to state a claim on which relief may be granted is non-waivable under Rule 12H2, and courts in this district have taken a tolerant approach to successively filed Rule 12B6 or 12C motions. The viability of Lively's remaining FEHA claims cries out for a resolution prior to trial. The issue is purely legal and requires no factual development. Resolution of the issue now, rather than in post-trial motions, will significantly simplify both factual presentations and the jury instructions. Among other things, if the FEHA claim is dismissed, both Wayfarer and TAG will be dismissed from the case. If the FEHA claim is dismissed, the jury will no longer need to decide whether Lively had a reasonable and good faith belief that she was opposing for retaliation forbidden under FEHA. If the FEHA claim is dismissed, the jury will be able to decide the case under a single set of instructions on contract liability and damages, and will not have to wade through two overlapping but distinct claims. There is no prejudice to Lively from this issue being decided prior to trial, so they're getting that argument in quickly because that is what she's going to come back with. For the foregoing reasons, the court should dismiss the FEHA retaliation claim against Wayfarer and It Ends With Us movie and the aiding and abetting claim against TAG. Wow. More than that, right? Not only would, if this is successful, right, not only would that mean that TAG and Wayfarer are out, no longer defendants, the retaliation is gone. That means the Section 47.1 remedies gone. And given between this filing, which, you know, supports TAG being dismissed, and TAG's own refiled motion for summary judgment, I would be incredibly surprised if one of them did not get TAG out of this. They are both incredibly well drafted, good use of the law, great arguments. So even if one didn't work, I would be absolutely shocked if both failed. So I personally think TAG are going to be out of this. Even if this doesn't succeed, I think the motion for summary judgment should. But this is so well argued, and to be honest, it's the second filing now in one night where they basically said to Lyman, your ruling is flawed. And I'm here for that. And what that kind of tells me is they're saying it's almost like an indicator of, if you go against this law, or if you create new law, which is, you know, beyond the scope of your powers, you in a federal court create new state law, which is what the MSJ said, then from the language that's being used, I'm getting an indication that they would be prepared to appeal if Wayfarer, the Wayfarer dependents, if they lose. And it's nearly 2:00 in the morning, so I'm kind of getting tired now. But it was so important. I wanted to talk about this because these are the two best filings we have. I'm going to have a weekend of it with the rest of the filings by the sound of it, and I'm absolutely fine with that. But these two filings are just absolute masterpieces, and I'm just loving seeing Wayfarer finally saying to Lyman, enough of your ridiculous rulings, enough of using the law incorrectly, or you have not considered this. Whilst all the way through also being quite firm with Lively and her attorneys as well to say, hey, look, we can do this. We've got time. It's not going to prejudice anything. And kind of meeting her anticipated counter arguments head on in this fight, in these, initial filings. I feel like I'm going to get a good night's sleep after reading these, and also seeing those wonderful new set of attorneys from the from Shapiro Arato. This is Wayfarer now are in it to win it, as far as I'm concerned. They've just upped their game and brought on some incredibly amazing new players into this. So I'm excited to see what else hits the docket. So I hope you guys are too, though. Let me know what you think of this, though, because I wasn't expecting it. It took me by surprise a little bit. I obviously was expecting the motion for summary judgment, but this I didn't. I don't remember there being any sort of warning or notice that this was coming. But it is absolutely masterful. One of the best things that has been filed this entire case, in my opinion. And it comes straight from the wonderful Jonathan Bach. All right, guys, I am now going to go to bed because I'm tired. Have a good evening, everyone. Enjoy the filings, and I will catch up with my own opinion on them, on what the other filings that I haven't covered yet over the weekend. Take care.